our series on the constitutional amendment. We've been doing this for over a year, and one of the vitalities of the American system is that our Constitution can be amended. As we serve the United States Capitol Historical Society, created in 1962, chartered by Congress, not funded by Congress, but chartered by Congress, to provide the story of the Capitol and the people who work in it in a manner that inspires informed patriotism. We consider it an honor to carry that story about the values of our country, the processes that are put in place for people to actually participate and form that more perfect union that is our democracy and our American Republic. So today, we're talking about the evolution of voting rights. There have been 3 amendments that we put together for this conversation, each of which expanded the opportunity to participate in the vote. In 1961, the 23rd Amendment passed, allowing District of Columbia voters to have electors to participate in the presidential election system. In 1964, the 24th Amendment eliminated the poll tax, which had been used to try to discourage low-income and particularly minority voters from participating. And in 1971, the 26th Amendment passed, allowing 18-year-olds to have the right to vote. The discussion then was, if you're old enough to serve in the war, the Vietnam War, which was quite controversial at the time, you ought to be old enough to vote about that. So think about this. Elections are critical to our American democracy, and our constitutional right to vote is fundamental to our democracy. Throughout that fight, we have seen the citizens stand up for their right to participate and their right to vote. We have with us to discuss this a very distinguished scholar. Professor Alexander Keyssar is the Matthew W. Sterling Professor of History and Social Policy at the Kennedy School of Government, a place I have a fondness for because I served as a fellow at the Institute of Politics there for a while. Professor Keyssar is a historian by training who has specialized in the exploration of historical problems that have contemporary policy implications. His book, The Right to Vote, The Contested History of Democracy in the United States, was named the best book in United States history by both the American Historical Association and the Historical Society, was a finalist for the Pulitzer Prize and the Los Angeles Times Book Award. A significantly revised and updated edition of this book was published in 2009. Professor Keyssar chairs the Social Science Research Council's National Research Commission on Voting and Elections, and writes frequently for popular press about American politics and history. And his latest book, which you may want to ask about in questions and answers, Why Do We Still Have the Electoral College?, is certainly appropriate for today's time, published by the Harvard University Press. So what we're going to do today is that Professor Keyssar is going to give some opening remarks about this whole question of expanding the right to vote and the constitutional protection for voting rights. And we have a broad conversation that we are going to allow all of you to participate by putting your questions in the Q&A, and I will field those to Professor Keyssar. So we're going into an election, Professor Keyssar. What do these amendments mean?
Well, first, thank you to the society for inviting me, and thank you, Jane, for the very generous introduction. And thanks to everybody who's out there. I can see that there are 144 participants listed. Thank you for coming, and then I assume other people will be watching this later. Yes, we are in an election season, as everybody with a pulse knows by now, and we and issues about the right to vote and the exercise of the right to vote are already running alongside the actual election campaign itself. I think that maybe the most useful thing that I can do is before getting to these three specific amendments is to sketch what I think is a broad arc of the evolution, the history of voting rights in the United States. Because even though we like to think of it, and if we look at just the history of the amendments themselves, it can look like a tale of steady progress. I mean, if you know, and there used to be a version of the history that was taught as well. At first, only white men with property could vote, and then they got rid of property requirements. And then after the Civil War, they got rid of racial requirements to vote. And then gender requirements were killed with the 19th Amendment. And then there was always a curious twist in it, because then there was the Voting Rights Act in the 1950s and 1960s, and it was, well, we got rid of racial requirements again, or racial qualifications for voting again, and there was some mystery about why the again. The fact is that the history of the right to vote in the United States is a history really of 2 steps forward and 1 step back. It's a history of significant and major advances, but of resistance to those advances, and in some cases, a reversal of advances that have been made. And one sees that not only in the ancient history of the 19th century, but one sees that in the 20th and even early 21st century as well. So the story here, the broad story here, is that this has been something of a struggle, and this has been a conflict. And you know, everyone seems to agree in the history that they and their people should be entitled to vote, but they're not so sure about everybody else. And that's not speaking for everyone, but there are these pockets of resistance. So with that as a broad background that I would want to sketch, let me zero in on first the period in which these 3 amendments were passed, and then say something about the amendments themselves. This period, a period from, you know, I think one might date it from the middle of World War II, or certainly shortly after World War II, into the early 1970s, is one of the most extraordinary appearances of democratic advance in the United States, globally as well in many respects. But within the United States, you have these 3 amendments. You have a number of other things that are taking place besides the amendments. The Voting Rights Act, which as legislation is passed in 1965 and then renewed and in some ways expanded in 1970. And meanwhile, the Supreme Court is also making decisions that remove barriers to voting, so that one can see this entire period as a period of very, very significant democratic achievement and democratic advance. Now, one can ask, why? Why did this happen? I mean, that's I teach my students that the historian's question is actually not to just ask why something happened, but why did something happen when it happened? And as is always the case with significant historical moments, the answer isn't simple. There's not one simple thing, but let me point to a couple of different factors. And many of these involve the history of race and racial suppression and voter suppression in the United States, but that's not all that was at stake. But one factor that contributed to the expansion of voting rights to African Americans in particular, and then from African Americans to other groups. One thing that happens is the service of many African American soldiers and Native American soldiers in the Army in World War II. It has historically been very difficult to argue that somebody should serve in the Army and not be entitled to vote. And that argument was put forward strongly. World War II and its immediate aftermath was also a period of genuine resurgence in democratic ideology and democratic belief. World War II, the official declarations say this was a war fought for democracy. Well, if you're fighting for democracy, you should you can be fighting for democracy at home as well, where you ought to have democracy at home. But and the ideology, I don't think the ideology was opportunistic. I think that there was a great belief in an expansion of democracy. There was also competition with the Soviet Union and a little bit with China, but mostly with the Soviet Union, over claims to be democratic, and particularly with respect to what was going on in the Third World and in Africa. In the propaganda, sort of contests of the Cold War, in the early 1950s, late 1940s, but early 1950s, the Soviet Union was saying to African nations and to African movements and those elsewhere in the world, well, the United States talks democratic, but look at the way it treats its own black people. Do you really want to align with them? So there's an ideological contest going on globally as well. And then, there's another thing going on that I think is very important is a change in the social structure in the South, which is making much of the South less dependent on black agricultural labor, thus accelerating the move of African Americans from the South to the North, which resulted in their being enfranchised and wielding political clout that could then affect national legislation. So that's this broad background about what's going on in the period. And now let me say a few words about each of these amendments. The 23rd Amendment, which may be particularly dear to the hearts of some people in this audience, if they are from the D.C. area, basically it gave the residents of D.C. the right to vote for president and to have electoral votes. This movement to do this had been going on for quite some time. It was very hard to defend a system which deprived a very significant number of citizens, more than lived in some states, of the right to vote. So this had been, a long time coming. It was also infused with some racial tones and some racial conflict. But this happened, and it happened pretty easily in Congress once it finally did happen. The 24th Amendment on poll taxes was more complicated. Poll taxes had been, over the last 20, 30, 40 years, had been a major issue. They were utilized predominantly in the South, although they had been utilized elsewhere in the country, including I'm sitting here in Massachusetts, and they were used in Massachusetts in the 19th century. But poll taxes by the 20th century were used almost exclusively in the South, and they were one of the mechanisms utilized to keep African Americans from voting. In fact, after an important Supreme Court decision during World War II, they briefly became more important because the Supreme Court decision in 1944 outlawed the use of the white-only primary, which had been in effect in the South from about 1910 until the middle of World War II. Basically, the white primary meant that the Democratic Party, which was the only party in the South, was construed to be a private club and could have whatever rules for voting it wanted. The Supreme Court had upheld that a couple of times, but outlawed it in 1944. So that puts some emphasis on other mechanisms. Getting rid of the poll tax was a major liberal or progressive political and social campaign item in the 1930s and into the 1940s. The South had resisted it, but on the other hand, by the early 1960s, by 1964, there were only 5 states in the South that were utilizing poll taxes. To the extent that they were disenfranchising African Americans, they were using other mechanisms to do so. So this amendment, again, is something that has built up, the momentum for it has built up over a long period of time. Resistance has weakened somewhat as the number of states using poll taxes has declined. And the 24th Amendment is passed and becomes the law of the land. But it applies here. Here's a wrinkle, and as is often the case, there's an interaction between what Congress does and what the Supreme Court does, which is that the 24th Amendment only applied to federal elections, did not apply to state elections. It banned poll taxes in federal elections, but states could continue using them. That terrain shifted when basically with the Supreme Court case called Harper versus Virginia, which happened within 2 years and produced a ringing declaration from the liberal wing of the Supreme Court that, and I'm quoting here, wealth is not germane to the exercise of the franchise, and poll taxes, this is 1966, were banned in all elections. And this is, I mean, one way to look at this, I mean, you can look at this as a significant achievement of the 1960s, but in a broader perspective, this is the result of 175 years of efforts to disentangle economic and financial requirements from the right to vote, from those property requirements in the early republic or the tax-paying requirements in the early republic. The legitimacy of a financial requirement to vote is only really definitively undermined in the 1960s. That's quite late in our history. Finally, let me talk about the 26th Amendment, which is not about race and is about age instead. And I have to say that as I was listening to Jane's introduction, the fact is I was one of those people in the 1960s who was draftable before I could vote, and who chanted those slogans that she was referring to about how we should not be sent to be killed by a government that we had no ability to participate in. But here again, the issue, I mean, as is always true with constitutional amendments, or almost always true, this issue had been building for quite a while. There were many arguments that particularly had to do with military service. During World War II, that there were millions of 18, 19, 20-year-olds who were serving in the armed forces but could not vote. There was not unanimity on this subject. Important member of the House, Emanuel Seller, who was, I think, chair of the Rules Committee, completely opposed the logic of enfranchising 18, 19, 20-year-olds. You know, he was saying basically what you want in an 18-year-old soldier is somebody who does not exercise their own judgment but will obey, and that's a different trait than what you want in voters. But still, support had been building for this. And then when with the Vietnam War and the resistance to the Vietnam War, the issue became increasingly salient as the anti-war movement utilized this, and as the issue of a 21-year-old age limit, which meant that many people, hundreds of thousands of people, could be drafted and could be forced to serve in the army without being able to vote. It also became something of an emblem of the absence or weakness of democratic support for the war in Vietnam. But then the history got complicated and a little twisted. In the late 1960s or 1970, I think it was 69 or 70, Teddy Kennedy, Senator Kennedy, working with Mike Mansfield, who was the majority leader, attached legislation lowering the age to vote in all elections to the Voting Rights Act, to the renewal of the Voting Rights Act in 1970. And again, the legislative history there is complicated as they tried to work that through. But they believed, although many people did not, that the age of voting could be taken care of by Congress and by legislation. Others thought that this was not going to be possible. As had been more or less prearranged, that legislation was challenged in the courts, ended up in the Supreme Court, where it got an exquisitely ambiguous result, which was that 4 justices believed that Congress could make this change by itself to all elections. 4 believed that they could not change it in any election, and 1 justice believed that, or argued that Congress could do this for federal elections, but not for state elections. So that became the ruling majority opinion. And by the time that case was settled, what that meant was that there would be in most states in the country. I think the only state that had lowered its age requirement earlier than that was Georgia, but that every state suddenly had a 2-tier age structure. You could vote in federal elections when you were 18, but you had to be 21 to vote in state elections. This was a potential administrative nightmare for election officials around the country, and they mobilized against it and overrode a number of objections. And the consequence was the swiftest passage of a constitutional amendment in U.S. history. I think that from the time that it got through Congress until ratification was only about 7 or 8 weeks. And the amendment was passed and lowered the age of voting for all elections. So that's the story with these amendments. I think in terms of the impact of them, obviously for people who live in D.C., the 23rd Amendment was impactful. There was a difference between day and night. I think that the 24th Amendment had relatively little direct impact, particularly given the Supreme Court decision that was going to follow, and that there were only 5 states that had poll taxes at the time. But it was one more nail in the coffin, so to speak, of these discriminatory policies. And the 26th Amendment was definitely has had an impact. I think that if you think about the issue of the mobilization of youth vote. Now, I teach at a university. Every 4 years or every 2 years, there's tremendous talk about this year we're going to get young people to vote, and then there's always after the election, well, they didn't vote that much, but maybe they voted a little bit more. It remains an issue, but the participation of 18 to 20-year-olds in elections is important and can have a consequence, and in many elections does have a consequence. I think the other significance, and this is where I would close here, of which we have to keep in mind, the significance of these being done through constitutional amendments, is that these are policy decisions that are being made that are not easily reversible. They become the law of the land, and they're pretty easy to defend because repealing a constitutional amendment would take another constitutional amendment, and that's very difficult to do. And I think that one could well imagine, for example, that in today's political climate, there might be significant impulses to reduce some of these advantages, to reverse some of these sort of advances in democratic rights if it were easily possible. Even possibly taking away the electoral votes of DC, but I speculate about that. But I do think that one of the important things about amendments is that it does make it does make it hard to change. Now, the difficulty of amending the Constitution is also, to my mind, a very serious problem. But we can talk about that if others are interested. Let me close my comments here. Let's open it up for discussion and questions. And I guess I turn the stage back to Jane.
Well, thank you, Professor Keyssar, for setting the stage. We have, as you can imagine, many, many questions. Let me just quickly ask one framing question. You are an expert in historical and cultural interpretation. And we have, how does the question of enfranchisement for DC, which now has electors for the presidential, but not a representative in Congress, as one mechanism. And then we have Puerto Rico, which has a different situation. Guam, you know, how does all that fit together?
I think the answer is badly. That if it fits together badly. You know, the histories of the history of DC is different. It was always carved out as a special category, unlike Guam and Puerto Rico, which are in significant ways legacies of U.S. imperialism. I mean, I actually testified in a hearing about Puerto Rico to the Civil Rights Commission earlier this summer, and you know, I mean, Guam and Puerto Rico have to do, you know, in good part with conquest of other territories, and the question of whether, as it was put at the time, whether the Constitution followed the flag. If we take sovereignty, but and a quip from the Secretary of Defense at the time, Elihu Root, saying that the Constitution does follow the flag, but it never quite catches up, and. So I think now, but then if you look at those three places, and this is more disturbing, what you find is that all three of these places, the residents of all three of these places are majority non-white, and so that fits into our history of discrimination, discrimination against non-white peoples. I mean, I think that. And then, you know, in the case of DC, I think there also are partisan reasons. I mean, I think that my understanding, and I'm sure that there are many people in the audience, including yourself, Jane, who know DC better than I do, is that part of the resistance, at least in recent decades, to DC statehood is that it would guarantee 2 more Democratic senators and 1 or 2 more members of the House, Democratic members of the House. And so there are partisan reasons for objecting to that. There are always, I mean, this is one of the themes here is that once you establish an electoral system, once you establish a franchise requirements of any sort, changing them could really have partisan implications and could really hurt one party or help one party or lead people to believe that their party would be hurt or would help. And then that plays into these decisions. It doesn't always determine them. Sometimes broader values commitments and ideological commitments override that. But there's always the possibility of partisan interests playing a role.
Which is probably why the DC member, so to speak, of the House is a non-voting person who doesn't have the full status to participate fully. Now, let me just try to follow on what you talked about, where a lot of this really comes down to racial politics and race questions. There was so much resistance when the enslaved people were granted their freedom during Reconstruction and they began running for office. There was political violence, particularly in the South, but not exclusively in the South. That voting becomes almost a proxy for power. How do you see these amendments and potentially any, amendments that may come up in the future as a component of that discussion?
Well, I think that, I think you're correct that these amendments and voting rights are seen as a proxy for power, and it's a question of who's going to stay in power, or who is going to retain power. I think it has also been the case that the situation of African Americans has long been, as maybe always, but certainly long been the most glaring and large example. I mean, we're talking about a significant percentage of the population. We're talking about in the slave states in the first half of the 19th century that they constituted 25 to 40, 45, 50% of the population of many slave states. But that the arguments that have been mobilized on behalf of enfranchising African Americans and broadening the franchise then become applicable to other groups. I mean, you saw that during Reconstruction when there was a significant, if failing, effort to say, while we're enfranchising African Americans here with the 15th Amendment, how about women? Why don't we enfranchise women at the same time? They are also citizens, et cetera, et cetera. And then it has extended to other groups, including Native Americans, more recent years, people who are non-English speakers. So it's both a major issue in itself, and it's also an ideological cutting edge. That's the way I would see it. And let me just add one more thing, perhaps a little bit controversially. And this is about the distinction between voter suppression and disenfranchisement. Because what we see in our current world are repeated claims and arguments about voter suppression, less use of the word disenfranchisement. And I think that the distinction between them is actually important, although voter suppression, I think, is what you do when you would like to be able to disenfranchise people, but you can't do it politically or legally. You can't ban them from voting. You can't because and the Constitution in many respects protects them. The 15th Amendment protects them. But you can put obstacles in people's path. You can make it harder for them to participate. You can create a lot of procedural steps and deter them. And that has been much more the modern route, in part because of the existence of these amendments that ban absolutely excluding people.
And could you compare today's attack on voting rights, as you call it, voter suppression, with that of previous eras, when we're looking now at voter challenges and 20 states that have, made it more complicated? You had to bring more identification or purging the rolls. What would you like to put that in historical context?
Sure, and I think the historical context is actually revealing. There are really two periods in U.S. history when this issue of voter suppression has become very salient. And one is the period, say, of the last 30 years that we've been living through. We quibble about whether it's 35 or 40 years, but the period that we know now. And the other is the period after Reconstruction. the late 19th century and the early 20th century in the North as well as the South. I mean, and this sort of I argue in the book, this is not purely a Southern story and a story about African Americans. It is a national story. And what you see are a lot of the laws that we're seeing today are versions of things that appeared in states in the United States in the late 19th, early 20th century. There was a reinstallation of certain kinds of tax requirements to vote. There was a literacy test in Massachusetts to vote. New York State passed an English language literacy test to vote in 1921, and it remained on the books into the 1960s. Or my favorite New York example actually is that that they in response to a lot of activist Jewish voters in New York City, New York had a kind of draconian registration requirement. You had to register every year. And one year in New York, they made the days of registration Yom Kippur and Rosh Hashanah, so that Jews couldn't register. It wasn't subtle. So you see, and I could go through the list, including the paperwork issue, the issue of having to bring proof of citizenship, et cetera. The same or very similar things to what we're seeing today. So the analytic question that I ask is, why is this happening again now, and how does it relate to this earlier period? And I think the answer is pretty clear, which is that both waves of voter suppression come after two things happen. One is after and during large waves of immigration from abroad, which was true in the late 19th century, and that's been true in more recent years, and the recent empowerment of African Americans, which happens during Reconstruction, and here in the United States in the 20th century happens during the second Reconstruction. The combination of African American empowerment and large-scale migration leads, appears threatening to a lot of people, and thus they move to limit participation in elections and to engage in voter suppression. That's the parallel and the historical roots that I would draw.
Now, let me just ask, we've got a couple of sort of framing questions. I'm going to hold the Electoral College questions to the end because that's a hot topic and we've got several questions on it. So we're going to end with the Electoral College. So all you who are freaking out that I haven't asked the Electoral College questions, don't worry, we're getting there. But one of the questions that someone asked is, you talked about the Constitution created a republic. We now talk about a democracy. What's the difference between a republic and a democracy?
I think the answer is the difference is not very much, and it may not be much of a difference at all. There's a difference in language. Certainly, the framers of the Constitution used the word republic, and in the English of the 18th century and earlier, democracy was kind of a negative word. It meant ruled by the mob. Although the meaning, the connotations of that word changed very rapidly in the United States. It meant in the 1790s, it still had that connotation. And within 30 years, you had a major party calling itself Democratic. So I don't think that operatively there is any difference. I don't think there was any conceptual difference in the minds of the framers. And I think that the distinction between democracy and republic is one that has often been utilized or mobilized politically in ways that distort the history. I think that the framers of the Constitution intended to create a government that was subject to popular control, although who they defined as the people was not exactly the same thing as the way we might define it today. For example, you, Jane, would be excluded.
Right. I know. Now, you spoke briefly about your concern about how difficult it is to amend the Constitution. We've not had a constitutional amendment since 1992. We had quite an effort to try to pass the Equal Rights Amendment. The DC folks continue to try to get secure home rule. And you could probably go through a list of folks who've been trying to figure out a way to amend the Constitution. What's your thought about? Is it too difficult? What should be done to make it more straightforward? Does our Constitution continue to be an amendable document in today's world?
Yeah, I think that my own view is that our Constitution is too difficult to amend. And in practice, it has turned out to be more difficult than I think the framers envisaged. Because, one of the things they were saying even around the time of ratification was, some of the wiser of them were saying, look, we probably got some things wrong, but, they can amend it in the future. But it's, the rate of amendment is, right, an average of what, since the Bill of Rights, it's an average of one every other decade. One amendment every other decade. So I think that the supermajorities have to be lowered or maybe not be so multiplied. I think that you could use a 60 vote threshold, and then you don't need rather than 2/3 in Congress, or you could and then the requirement in the states of 3/4 agreement could be diminished, or maybe. And I haven't thought about this very carefully. Maybe there might be other paths to amendment besides Article 5 conventions. But I think that, my own view, and not everybody shares this, but my view and the view of many people I know is that the Constitution is should be a living document. Our Constitution is incredibly short. I often have my students, I make them go look up or go get a copy of the Constitution. When you print it out on a normal printer, it's about 8 or 9 pages. That's it. And then if in most of the countries that a lot of my international students come from, you look at their constitutions and they're 240 pages. And our Constitution has survived because it's been flexible, but I think it's not flexible enough. And the way it has worked, since the amending process is so difficult, has been to transfer the power of changing the meaning of the Constitution to the courts. And I don't think that that's necessarily healthy.
But in fact, to change the supermajority or the number of states would take a constitutional amendment in and of itself.
Yes, you are.
Which brings us to the whole question about the Electoral College. Why does it still exist, and what would it take to change it? I know you wrote a whole book about this, and I've only given you a short time.
Right. Why it still exists is actually a complicated question over time, or within what we mean by the Electoral College. The term Electoral College is not in the Constitution. It's largely a 20th century term. It shows up a little bit in the 19th century. The institution has been, well, there are two pieces. One question is why we haven't succeeded in getting rid of winner take all. I'm actually writing a piece about that now, but many people, going back to 1800, winner take all is not in the Constitution. People have wanted to get rid of it. We've come very close on a number of occasions, but it's hard to get agreement about exactly what to replace it. But the other part of the story, which I think is in the minds of a lot of modern citizens, which is, why don't we have a national popular vote? Like why don't you choose the president the same way you choose the governor of your state, or the head of the student council. Why don't you do that? And the answer to that is more disturbing. That for most of our history, switching from the Electoral College system to a national popular vote has been ferociously opposed by the white South because it would diminish their power. And to state this let me give a historical fact and then a basic notion. One way to understand the way the Electoral College works is that it gives power to states according to their population. In other words, the number of electoral votes it gives to the states is roughly commensurate with their population, not commensurate with the number of people who vote. Or another way to state that is that there's no penalty for a state in terms of power to engage in voter suppression or disenfranchisement. And if that's not clear, I can expand on that. But for example, in 1910, when this came up a lot, and there were some studies that were done that the number of votes that were cast in 2/3 of the South, and don't hold me to these details, but it's something like that, was less than the number of votes that were cast in the state of Ohio. But those 2/3 states of the South had 3 times as many electoral votes. That's sort of the principle behind it. The historical reality is not only were there many blockages in the late 19th and in the 20th century within Congress, but we did come, and most people don't know this, we came very close to abolishing the Electoral College in 1969-70. I mean, this is really a suppressed history. The House of Representatives approved a constitutional amendment to replace the Electoral College with a national popular vote by an 82% vote in 1969. I mean, your eyes light up, and with good reason, because right now you couldn't imagine the House voting by 82% on what time it was, but an 82% vote in 1969. It then went to the Senate. And Senator Birch Bayh of Indiana was sort of the hero ushering this through. It was stalled in the Senate by various people, including the chairman of the Judiciary Committee, James Eastland, who was a noted opponent of civil rights. He was from Mississippi, and it was stalled for about 10 months. Bayh finally got it through, and it was killed by a filibuster in the Senate in the fall of 1970, led by Eastland, Strom Thurmond, and Sam Ervin, all of the South. And they believed, as did many people, and there were books that were written about this, that the Electoral College was the primary defense of, and I used to quote the phrase, the Southern way of life. So race was implicated in this at that historical moment when it just might have gone the other way. It still got a majority vote. I mean, the closure votes got a majority vote in the Senate. They were never able to bring it to a vote.
Yeah. So if you were to say, what of the amendments that have been brought forth and enacted, is there any one of them that is the most important for setting forth voting rights?
I mean, it's hard to give a hierarchy. I mean, the 19th Amendment, enfranchises half the population. It's hard.
I'm partial to that one.
I'm shocked to hear that. And the 15th Amendment, obviously, with respect to race, the 14th Amendment, as interpreted by the court, at least in the past, has used the Equal Protection Clause of the 14th Amendment, has been utilized to prohibit all sorts of rules, restrictions on voting, like residency requirements or literacy requirements. So it would be hard to exclude the 14th Amendment, given that. But I'd say that one of the ways to look at the amendments to the Constitution and at the Constitution itself, a lot of the amendments of the Constitution that we've had since the Bill of Rights have been about voting or electoral mechanisms of one sort or another, and they are about shoring up the holes in the protections or expanding the rights of the American people, and that's an enviable track record.
So our final question is, what would it take to change the Electoral College? Would it take a constitutional amendment? Could Congress do it on their own? How could you do that?
My own view is that it will take a constitutional amendment, and that it's misleading to suggest that it can be done otherwise. There is a whole, campaign for the National Popular Vote Interstate Compact, and I think that it is deeply problematic, in part because it would be necessarily impermanent. I think that this is a case where you want to change the Constitution. And what you want in an electoral system is a system that is transparent, and that is understandable to everybody. And that's certainly not true for the Electoral College, and it's not true for some other attempts. I think that we meaning those people who would like to get rid of the Electoral College, which is a significant majority of the American population, by the way. As long as we've had polls, most people have said, just get rid of it. Let's have some other mechanism. I mean, you could go for a national popular vote. You could use a proportional system of distribution of electoral votes in the states, but you can't make it enforceable and binding without a constitutional amendment. So I think that advocates of reform need to bite the bullet. And I would say that, I would also say here in closing, is that in recent decades, the Republican Party has tended to oppose any kind of Electoral College reform. They've seen that the Electoral College is offering them an advantage. And I would say to people of that persuasion, don't let yourself be guided by short-term advantage. If you look at the long history of this, the partisan advantage has gone from one party to another. It can swing from one election to the next. If you choose your electoral system according to the principles that you believe in, not according to the advantage you think you may or may not get, because that's going to change over time anyway.
Well, Professor Keyssar, we are so grateful that you donated your time to offer your talent, your wisdom, and your experience to our listeners. We are grateful to each and every one of our listeners who joined in and join in every week or every month when we do these. We are always use these last moments to remind you that we're only able to do this because of the support that comes to us from our members and our guests. And so we hope that all of you who are listening become members of the Capitol Historical Society. Right now, we're in the process of doing a campaign to try to raise money to make sure that our civic education program that we provide for DC middle school students in the most impoverished schools, we're able to provide those buses. So any contributions you make, we would be most grateful for. This program has been recorded, will be available on our website and our YouTube channel, as are all of our webinars. We are grateful to be able to offer public history in a manner that inspires informed patriotism, as is our charge. Looking ahead, we have Judge Burt Griffin from Cleveland, Ohio, who served as a young staff attorney on the Warren Commission, speaking to us about, we were originally scheduled, this was originally scheduled, and Judge Griffin had some health problems, so we've rescheduled this to talk about JFK, Oswald, and Ruby, the 60th anniversary of the Warren Commission. We have a very interesting webinar coming up on Thursday, October 3rd, Founding Partisans with Dr. H.W. Brands. We are aware that that date is a Jewish holiday. It will be recorded so that people can participate, by watching it later. If you have questions for Dr. Brands that you would like us to pose, please send us a note and we'll make sure that those questions get posed. I'm sorry that we missed that holiday. Dr. Brands indicated his availability at that time, so we will be doing it with the recording. And then coming up on the 17th of October, we have Lincoln and the immigration with Harold Holzer. All interesting and coming up, so we look forward to your participation. Thank you very much. Take care and have a wonderful day. Goodbye. Thank you, Professor.
Thank you.